I try to summarize my brief intervention. I'd like to share an Italian experience and also our experience in connection with the liability of arbitrator with regard to the crime of bribery. It is an extreme story of corruption, which show also the lack in Italy of protection in a situation like that. The point is that in Italy, to be charged with the crime of bribery, a person must be a public official or must be in charge with a public function. And the point is that in Italy, these are articles important to understand who is a public official, who is a person in charge with a public function. But in Italy, from a substantial point of view, arbitrators are public officials because they perform a public function, justice. But from a foreign point of view, they can be considered public officials because a specific article 813 of the Code of Civil Procedure states that they can be considered from a foreign point of view public officials. So there is a very big problem in case of corruption. And just to summarize, because we have no time, I go very quick just to speak about the case. We assisted an American company, insurance company, and in this case, a broker committed the crime of misappropriation of 50 million euro. We filed a complaint against him. We obtained a seizure of the amount, and the broker was dismissed from the company. But after that, the broker decided to open an arbitration against the company, asking 3 billion euro without any grounds, And it was clear that there was any grounds. Civil lawyers said, no, we are sure we win without any problem. Okay. But after the appointment of the president of the arbitration panel, it was clear that the arbitrator was favorable to the broker, okay, and spread up a lot of rumors about the particular relationship between the president of the arbitration panel and the broker, and it was said that the only viable option for the company was to reach an agreement, paying not less than 500,000 million. Okay, so we went to the prosecutor. We said there are a lot of problems, but he said, yes, you are very weak because from a point of view you have no proof, you have clues, okay, some clues, and I can't be strong with clues. And from our point of view, it is difficult to act against an arbitrator because he is not a public official. We can try to prove that he is, but it is very difficult. But I'm not closed, said the prosecutor. I can't do substantially anything. Try you, with your own strengths, to do something. So we decided to appoint a team of private investigators, and that team did a very interesting work because with a very deep work they obtained two recorded of conversation, very important. They obtained a recorded conversation with the broker. They pretended to be businessmen who wanted to hire the broker, and they said to the broker, yes, we'd like to hire you, but we know that you have a lot of problem with an American company, we know that you are under investigation, you know that there is an arbitration, how can we do? And after a lot of meeting, all recorded, he said, no, don't worry. I have the arbitration under my control because I promise the 10% of what I reach to the president of the arbitration panel. And it was recorded. And they obtained another recorded conversation with the president who said, I'm able to, another fake businessman, yes, I'm able to control arbitration in Italy, and it was enough. So we went to the prosecutor with these proofs. He said, I can't stop now the arbitration because there is the problem of the public official. And this is the point which we are underlining today. So we decided to recuse the arbitrator in front of a civil judge, and we obtained the recusation. And we went ahead with the criminal proceeding. But the criminal proceeding was concluded with this statement. Article 813 is a legal barrier to the qualification of arbitrators as public officials, and as consequence to application of the crime of corruption against arbitrators. Okay. And this is important to underline, but the European Council decided to okay, a lot of slides you can read, but we have no time. Okay, to urge the Italian legislature to adopt measures in order to have the internal anti-bribery law compliant with the rest of the Union. And we hope that this happens. So now Italy is very weak. The story of arbitration is very particular, and they can't be charged with the crime of bribery. This is our brief experience.
Everyone is shocked, I think.
Yes.
Can I just...
Yes.